Dear beloved Creator, we are an assembly, assembled in trust and in love with one another for the gifts each brings. We are part and particle of you, and we gather, enjoying these moments of acknowledgement. It is by our request that we move in your grace and protection. It is by our great gratitude that we collaborate our shared vision and actions, taking one faithful step at a time. We have a goal and a mission. I say we are there, and we're here to claim our status in service to you. So, as a servant and child, not innocent, but receptive of all the love and nurture you give as we move on our courageous journey. And so it is.
Amen. Thank you, Charlie.
My pleasure.
Yes.
Hello, Major Carol. Thank you for taking my call. I expected I have only one shot at this, so I will get right to the point. We need a USMC major or better on Oregon to assess the situation for the Commandant of the Marines, General Eric M. Smith. We have lawfully determined this is a USMC responsibility. Notice to the agent is notice to the principal. Oregon has led the way and accomplished as much as we can without your assistance. All of us on Oregon implemented ex parte Milligan and nullified martial law with our civilian court of record. This in turn led us to our grand jury on Oregon as an Article 1, Section 1 social compact, Oregon's provisional de jure government. We are a government with an Article 3, 1 Supreme Court claiming original jurisdiction found in Amendment 7, lawfully and legally, on Oregon in 2022. This was accomplished by the Oregon Statewide Jural Assembly, aka Article 1, Section 1. We have dozens of lawful documents, some of which are grand and petite jury trials, signed, sealed, stamped, and witnessed with proper proof of service and published on our website, www.orsja.org. These were acquiesced to by US DOJ, USMS, FBI, USMC, the State of Oregon, aka all caps State of Oregon's executive, legislative, judiciary, 36 sheriffs and 38 prosecutors, provost marshal, and JAG, defaulted to many times over. This same process, what we have done here on Oregon, is available to the other 32 states and commonwealths and the 17 territories. We need your help to reclaim our republic and to reestablish de jure as the law form as opposed to the de facto currently existing. We know our country is divided. The parties are divided within themselves. The people are in confusion and have been deceived to the point of not knowing the truth. Even the military is divided. We are de jure, people on the land and soil with the simplicity of common law, where only injury to another or to property is punishable, and where our courts have no judges but are provided to resolve issues among the people by the people. What we have instead, and have had since approximately 1861 and increasingly, are de facto courts, all corrupt RICO operations with their judges and attorneys benefiting from a monetized CRIS system, practicing authority over people with their incorporated malevolent color of law governance, where the city of Portland is a subdivision of the county of Multnomah, is a subdivision of the state of Oregon, is a subdivision of the United States of Washington, District of Columbia, Inc., with forts, ports, armory, and needful buildings, operated by an industrial, military, executive, legislative, judicial, administrative, banker, FRN, BAR, Nazi, Jesuit, Khazarian, jihadist, communist, U.in. Big Pharma, medical, de facto, color of law, RICO society that should not be. So we took them out on Oregon, November 2022. What we need now from you is to take the work our assembly and our civilian court of record with its original jurisdiction has accomplished and force these de facto criminals, crooks, politicians, judges, attorneys, and DAs out of their positions of power based on our evidence of their corruption. They imposed what happened with the debacle that destroyed people's lives and businesses, their physical, mental, and emotional well-being, and continues to manifest serious problems in the culture. Our civilian marshal, Bobby Graves, Marine, and Deputy Marshal Jason McBride need support in enforcing the work we have done and are continuing to do to set things right for the people. We have taken to task all the agencies and associations and authorities on Oregon that interfere with our inherent God-given unalienable rights of peace, safety, and happiness. Now we need the clout only those of your agency can enforce. I made a statement. At what point did sensible enter into this? To walk away is sensible. To acquiesce, quisling. Inability to say truth to the de facto makes up 62.5% plus of the population. There is a large dispossessed population. A very small percentage will do Athens, Tennessee, 1946. I drew a line. Not one infringement on my unalienable rights granted by my God will go without challenge. It is codified on the land and soil of the United States of America's constitutional Republican form of government circa 1859, original jurisdiction. The definition of sovereign are twofold here. A chief ruler with supreme power, one possessing sovereignty, Q.V. It is also applied to a king or other magistrate with limited powers. The second is, in the United States, the sovereignty resides in the body of the people. Vide Rutherford Institute 282, and that's a definition of sovereign from Bouvier, 1856. Sovereign are men and women with their progeny on the land and soil without ruler or subjects. The de jure jurisdiction of the United States of America's Constitution, circa 1859, original jurisdiction. The only codified government in history where, as in Article 1, Section 1 of Oregon's Constitution, circa 1859, quote, natural rights inherent in people, we declare that all men, when they form a social compact, are equal in right, that all power is inherent in the people, and all free governments are founded on their authority and instituted for their peace, safety, and happiness, and they have at all times a right to alter, reform, or abolish the government in such manner as they may think proper. End quote. We returned to that on October and November 2022. Please accept this living testimony in the form of an affidavit of truth. This is from Ron Broman. I am known as one of the people, clerk of our civilian court of record, having implemented ex parte Milligan, nullifying Marshall Code, Lieber Code, FEMA, and Article 1, Section 1, aka Oregon Statewide Jural Assembly's Article 3.1 Supreme Court claiming original jurisdiction of Oregon, the state among the several states in the constitutionally de jure law form of the United States of America's Constitution and Oregon's Constitution circa 1859, Ron Vroman, the common man, private. Ronald Charles Vroman in cursive on my birth certificate and as trustee of the Private Membership Association. Ronald Charles Vroman, the straw man in all caps, also known as Ronald Charles Vroman, Private Attorney General by the United States Congress, 42 U.S.C. 1988 and 18 U.S.C. 1510 and 18 U.S.C. 1512, and to be known as one of the people, also qualified criminal investigator and federal witness, and by living testimony without rebuttal. Status identified and without rebuttal in the city of Beaverton, public record, Beaverton Municipal Court, and the United States Federal District Court, Portland, Oregon. U.S. Navy veteran 5159365 discharged. The flesh, blood, and soul, body, mind, spirit, a man on Oregon, an Oregonian, a continuous traveler, a non-U.S. citizen, born August 14, 1938, Reno, Nevada, with two ancestors, a father and son direct bloodline that fought for New York in our revolution. My mother's father, born Stockwell Gonzalez in 1876, New Mexico. Mail, general delivery, Beaverton, Oregon, 97005, in brackets, 503-641-8375, Ron Vroman, 38 at gmail.com. With full faith and credit, governing laws established in this document at this time to be the following. Declaration of Independence, Articles of Confederation and Perpetual Union, Oregon's original constitutions, circa 1859, and the United States of America's Constitution, circa 1859, and ORCP 20A, Clearfield Doctrine, Accardi Doctrine, Ex parte Young, Ex parte Milligan, McCarran-Walters Act 1952, Judiciary Act 1789, Section 32, judgment, nil deceit are all specifically called into this document. They are all governing law, which must be accepted. The current 13th and 14th Amendments are bogus and must be rejected. Take heed of the Blackstone commentaries. The DOJ is agent to the entity responsible for the enumerated requirements of Article 3, the one Supreme Court that must claim original jurisdiction to be a court. I would consider to have jurisdiction when found in conjunction with Amendment 7 court. The DOJ has failed miserably in their responsibility. We must do it ourselves. We define the words we use. We decide our methods of communication. This communique is not intended to mislead, defraud, deceive, or threaten in any way, and is submitted in good faith and with clean hands. I do lawful, not legal, and this is my best effort. I close with love, peace, harmony, and a prayer. A U.S. Marshal has determined my prayer is not a threat. He then reneged on his word, which is only good one time. Praise the Lord and pass the ammunition. On Oregon without the state of Oregon, aka state of Oregon within the United States of America, the constitutional Republican form of government. Assistance request in lieu of a demand is what we think proper. Article 4, Section 4. Please send to us a major or better to examine our bona fides and report. Our Marshal, Bobby Graves, USMC, wants a man that brings a battalion. I agree as an old sailor, by sea up the Columbia. Bring your own brig. All the best of every good fortune for the good. The old white man talking head for the Oregon Statewide Jural Assembly, the Article 1, Section 1, Provisional Government on Oregon, 10/16/2023. Ron Droman. You'll find us at www.orsja.org. Thank you.
My name's Ron Vroman. I'm the old white man talking head for the Oregon Statewide Jural Assembly. This is a recruitment video of men and women on the land and soil of Oregon, nowhere else. The Oregon Statewide Jural Assembly, probably 2 years ago, when we were talking to the militia, told us that they had trouble with law enforcement calling them domestic terrorists. So at that time, we formed the Oregon Statewide Jural Assembly Second Amendment Well-Regulated Militia. And it's time that we start recruiting for that organization. William's got some pictures that he can insert here of us at grand jury in the park. And I'm pretty sure the banner that we had up that day was our recruitment banner for the Second Amendment. I'm not positive, but it looks to me like, it looks to me like we may just skip over the do it lawfully part and have to skip right into the musket part. And so we should have a recruitment video for Oregon's well-regulated Second Amendment militia, which we are. They all acquiesce to that. The DOJ, FBI, Marshal, all of them. So that's who we are, lawfully, legitimately, de jure. And we need to recruit for the militia. It seems there was 4,000 in the militia when Kate Brown or Kulingoski or one of those decided to rearrange the militia and break it all up and put it under her control, more or less. That's what I understand from what happened. On Oregon, there's supposed to be a regulated and unregulated militia by our Constitution. And we could probably find it in the Constitution and show it on the screen, but read it for yourself. And like a court, if you're paid, then you're an employee and you're no longer the court. So if the militia is paid and part of the National Guard and under the control of the governor or a general, it's no longer the militia, it's their militia. We lost ours when we took their pay. Do you see the point? It's like our court. When our court meets and we do the work, that work is the culmination of all the investigation and effort that went into making a presentation to our court and doing it lawfully and legitimately all the way down the line. So what happens if there is no lawful resolution? There's no way that the entrenched oligarchy in Salem that's been there since November 8th, 1910, in whatever form that it happened to be or presenting itself along the way, mostly Democrat for the last 50 years, they've bent the state to the point where it's a subdivision of the United States of Washington District of Columbia, Inc., and it's no longer Article 4, Section 4, or a constitutional Republican form of government. It's disappeared. The oligarchy on Oregon is entirely in charge of all the divisions of all of the governance available. And the guy at the IG at the Marine Corps says it's not his jurisdiction. The Inspector General of the Marine Corps says that's not their jurisdiction, that we have enemies from within, convicted. Not my opinion. All signed, sealed, witnessed, published on our website. We've done the work. They're criminals, and nobody will prosecute on Oregon. So now we're up to the Marine Corps and the Coast Guard. Who will step up and do their constitutional job? Well, it might just be the Second Amendment, well-regulated militia. What was that? Lexington and Concord Bridge? Something like that. So we're going to have recruitment for the Second Amendment well-regulated militia on Oregon. And you can contact us at www.orsja.org. And my phone number's on this, and Williams, and emails, and everything else you might like to have to contact us. And like our jury pool, you'll do it in your own name and have two witnesses that this is what you want to do. And just like we did for the jury pool, this is recruitment for the Second Amendment well-regulated militia on Oregon. And I yield.
Article 1, Section 1 of Oregon's Constitution, Natural Rights Inherent in People. We declare that all men, when they form a social compact, are equal in right, that all power is inherent in the people, and all free governments are founded on their authority and instituted for their peace, safety, and happiness, and they have at all times a right to alter, reform, or abolish the government in such manner as they may think proper. Ex parte Milligan, 71 U.S. 4 Wall 2, 1866, was a landmark decision of the U.S. Supreme Court that ruled the application of military tribunals to citizens when civilian courts are still operating as unconstitutional. In this particular case, the court was unwilling to give President Abraham Lincoln's administration the power of military commission jurisdiction, part of the administration's controversial plan to deal with Union dissenters during the American Civil War. Justice David Davis, who delivered the majority opinion, stated that martial rule can never exist when the courts are open, and confined martial law to areas of military operations where war really prevails, and when it was a necessity to provide a substitute for a civil authority that had been overthrown. Chief Justice Salmon P. Chase and 3 associate justices filed a separate opinion concurring with the majority in the judgment, but asserted that Congress had the power to authorize a military commission although it had not done so in Milligan's case. The landmark case stemmed from a trial by a military commission of Lambden P. Milligan, for whom the case is named, Stephen Horsey, William A. Bowles, and Andrew Humphreys, that convened at Indianapolis on October 21, 1864. The charges against the men included, among others, conspiracy against the U.S. government, offering aid and comfort to the Confederates, and inciting rebellion. On December 10, 1864, Milligan, Bowles, and Horsey were found guilty on all charges and sentenced to hang. Humphreys was found guilty and sentenced to hard labor for the remainder of the war. The sentence for Humphreys was later modified, allowing his release. President Andrew Johnson commuted the sentences for Milligan, Bowles, and Horsey to life imprisonment. On May 10, 1865, Milligan's legal counsel filed a petition in the Circuit Court of the United States for the District of Indiana at Indianapolis for a writ of habeas corpus, which called for a justification of Milligan's arrest. A similar petition was filed on behalf of Bowles and Horsey. The two judges who reviewed Milligan's petition disagreed about the issue of whether the U.S. Constitution prohibited civilians from being tried by a military commission and passed the case to the U.S. Supreme Court. The case was argued before the court on March 5th and March 13th, 1866. Its decision was handed down on April 3rd, 1866. Prepared by Francis Lieber, promulgated as General Orders Number 100 by President Lincoln, 24th of April, 1863. Instructions for the Government of Armies of the United States in the Field, prepared by Francis Lieber, LLD, originally issued as General Orders Number 100, Adjutant General's Office, 1863, Washington, 1898, Government Printing Office. Article 1, Section 1 of Oregon's Constitution, Natural Rights Inherent in People. We declare that all men, when they form a social compact, are equal in right, that all power is inherent in the people, and all free governments are founded on their authority and instituted for their peace, safety, and happiness, and they have at all times a right to alter, reform, or abolish the government in such manner as they may think proper. This is taken from oregonlaws.org.
They do not want to let go of this. They do not intend on losing here. And we do not intend giving it back to them.
And then the bullets started flying. Then he jumps out of the car, and he's got both his hands up. And he got out of the car, and he had his hands in the air. He's like, just shoot me then. This is what you want, just shoot me. And they did. They shot him dead. With his hands in the air, and I saw it. I swear to God. He was just walking with his hands in the air. And they shot him. And they shot him dead, and then after he was down on the ground, they shot him 3 more times.